In order to get CLE credits, you have to listen for the secret word. It will be repeated twice during the video presentation. And sometime during the original presentation, Karen CORSI gave a secret code and she announced it and may have even held up a sign. And you need that code as well. So there's two codes, the secret word, which is audio only, repeated twice, and the one where Karen CORSI said it on the day of the presentation. Jot them down as you listen. You obviously have to pay attention. Good luck. Excellent. Well, good morning, everybody. Many of you who have taken these programs in the past remember me, Joe Del Russo, and I am the de facto education coordinator for the Passaic County Bar Association. I collaborate with Karen, especially at the end of the year. We like to offer these programs at the end of the year because that's when a lot of people, like always, wait till the last minute, just like me. So these are good opportunities for you to get your credits. We offered some that gave you your ethics credits a few weeks ago. I did one on AI maybe a week or two ago. We have one coming up on December 18th with Susan Curcio, former chief of sex crimes in Atlantic County for many years, argued cases before the Supreme Court. She's really a good presenter. On December 18th, 2024, you can get your DEI credits. You know, some of your ethics credits have to be DEI. So think about that. We'll offer them to you on December 18th. In any event, I saw this program in the summer and I was so impressed with Warren Sutnick. I don't do a lot of DWIs. Since I left the prosecutor's office, I have a few clients here and there, and I've done maybe 8 or 9 DWIs. But it's a fascinating area of municipal practice. It's one that's undergoing some change over the past 12 months and even a little bit longer than that. And the details of that, what's changed, how it's changed, and how that impacts you is something that we're going to talk about today. So in any event, the little bit that I learned about DWIs when I left the prosecutor's office, I learned from Chuck Festa, who's a Little Falls lawyer, and Matt Priori, who I share office space with in Clifton. And since they trained me, I think collectively my clients have had 10,000 days of suspension. No, they taught me the right way, I think, and I've been pretty successful. Once you learn how to deal with these cases, it's rather straightforward. What we want to talk about today is what are the changes. So Chuck, why don't you tell us who our presenters are today in this program? I'm not drunk, just restless.
Thank you, Joe. Thank you, everybody. And thank you, Joe, for putting it all together because Joe has assembled quite a very interesting and exceptional panel today. I think once you hear from them and about them, I think you'll agree, represent a very good cross section of all the components that go into a DWI case, from the defense, the prosecutorial end, the judge, and we're going to hear from the technical end, the new development that's taken over DWI and become a main part of it is the interlocking device. So with that being said, we're fortunate to have Warren Sutnick be the main component of our panel today. He's going to run the PowerPoint presentation. Warren's a Bergen County attorney who specializes in DWI and his practice, and he's certified by the Supreme Court as a municipal court attorney. He handles thousands of these cases, and he's going to speak from the perspective of his extensive knowledge and training in the field today. And I think you're going to really enjoy what he has to say and bring to the table today. We also have, from the prosecutorial end, Hisham Masri, Hesh as we call him, is a prosecutor in the Patterson Municipal Court and the Prospect Park Municipal Court, and is well versed with handling the DWI prosecutions and pleas from the perspective of the prosecutor in the municipal court. Similarly to Hesh, Maite Matos is also a prosecutor in municipal court. She sits in the Patterson Municipal Court and is the Chief Municipal Court Prosecutor in the Montclair Municipal Court. And Maite will also be sharing her perspective from the prosecutorial end of the DWI cases. We are also very fortunate to have the Honorable Tony Belford Damiano joining us today, who will be representative of the judiciary in the role of DWI prosecutions and handling of the cases. And everybody knows Tony. She's the Bar Association president here in Passaic County and the current municipal court judge in Woodland Park and the former municipal court judge in Little Falls here in New Jersey. And Tony has a vast experience in family law practice and sits on many boards in the state, especially surrounding the ethics, attorney ethics and things of that nature. And Tony will be a very knowledgeable person to hear from with respect to her area of expertise. And lastly, from a non-attorney standpoint, we have Mr. Jason Guberman. Jason is the owner and operator of Interlocking Device of New Jersey. Now, the interlocking device is for those who haven't or don't know about, is a machine that they put into the vehicle that you have to blow into before your car could start and drive. And with the last couple of years, has been a main component of any sentence you get in a DWI once you're found guilty or you plead guilty. So Jason's going to share with us today his experience from his end dealing with the DWI and the interlocking device, which is now a main area of the law. So with that being said, let's turn the program over to our panelists. I believe Warren's going to start, and enjoy, people.
All right, thank you. Joe, you can hear me okay? We're good?
We're good. You are displaying the slides and we can hear you.
All right, terrific. All right, first of all, thank you everybody for coming. Joe, I really appreciate you organizing this. We did this about 4 or 5 months ago in Bergen County. It was very well attended. And it's an appropriate time of year, I guess, to revisit DWIs, given that we're all going to holiday parties after work and on weekends. And I guess if there's one thing we all should glean out of this presentation is, after today's presentation, we should all call Jason and install interlocks in our car today. Because first of all, it'll protect all of us. Secondly, if anything happens, we're getting credit for our suspension. So it's all a good way to get started. And I will say, and I'll come back to this later, I've worked with Jason a lot over the past couple of months. There's a lot of interlock companies out there. This is not a paid commercial or anything, but I will tell you, he is outstanding. He's a local New Jersey company. It's not a national company. So if you have any issues at all, whenever I have a question, I can reach right out to him. And when he gets to the part of the presentation where he demonstrates the interlock device, I think it's really going to be interesting for everybody because we all talk about these interlock devices, but honestly, many of us have never even seen them, let alone see how they actually work and what the process is. Okay, so with that getting started, the way we're going to work this is I have about a dozen slides or so. We're going to go through those. The whole thing will take maybe 15, 20 minutes. I'm certainly going to have some questions for our co-panelists, Mate and Hesh, and Judge Damiani about their perspective on things and how a lot of this has really unfolded over the past 8 months or so since this law went into effect. So with that, let's get started here. Let's see how we can move on to the next slide. There we go. Okay, so look, DWI in the state of New Jersey and across the country has really been a major focus of law enforcement for generations. And the reason for that is because, sadly, it is one of those offenses that what I always say to my clients is nobody ever goes out at night saying, I'm going to go get drunk and then I'm going to drive. It is the type of offense that when a person has alcohol, their judgment is impaired. And many times, and probably most of the time, people don't really think that they're intoxicated. They think, I'm 2 or 3 miles from my house. I just shared a bottle of wine with my wife. I'm fine to drive home. It is one of those offenses that nobody really does on purpose. It's different than many other criminal offenses. Somebody goes in the Target, they intentionally shoplift something. somebody has an illegal drug on them, they know it's illegal. But drunk driving is certainly one of those things that what I say to my clients is nobody would ever drive drunk if they were sober. Because when you're sober, you know I shouldn't drive drunk. But unfortunately, when alcohol gets in a person's system, they're not thinking as clearly. Mothers Against Drunk Driving has been all over this issue for years. And these are just a couple of stats I want to throw out to people so they recognize, and of course we all do, how significant drunk driving is in the United States. Literally every 39 minutes in this country, a person is involved in a crash with a intoxicated driver. These statistics are from 2021, the most recent statistics. Over 13,000 people that year died in the United States from alcohol-related offenses. And over 400,000 people were injured or died in the United States from drunk driving. And it's amazing to me with all the rideshare opportunities that exist nowadays in most parts of the United States, whether it's Uber or Lyft or some other rideshare, that people still will go out at night. They'll go to an event, they'll go to a wedding or bar mitzvah, they'll go out to a dinner party, a holiday party, and they can go to that party knowing that there's a way to have a couple of drinks and safely get home that night, and yet still people don't. 1 in 4 crashes that teenagers are involved in involve alcohol, right? And that's a scary thought also, because that's high school kids, that's freshmen and sophomores at college, and that generation knows how to use Uber and Lyft probably better than many of us do. It's been part of their lives from when they were in high school, and yet still they don't have the education and they don't have the forethought to know that they shouldn't really drink alcohol at all, let alone have a drink and then get into a car and drive. 2 out of 3 people, over 60% of people in the United States, are going to be impacted by drunk driving sometime in their life. That means that they know somebody, a family member's been involved, somebody that they know has been injured or killed. They themselves have been caught driving while intoxicated. In the state of New Jersey, over 26,000 DWI arrests occurred during the period of July 2022 to July 2023. Now, sure, that's a lot of opportunities for us to do defense work, but at the same time, it is a scary thought that if 26,000 people were caught driving, just imagine how many people were not caught. Okay, so let's get into it. And again, we're going to move along pretty quickly on some of this stuff, but for generations, the DWI law in the state of New Jersey was the same. Over the past 5 years, we've had 3 major changes to that, okay? The biggest one is prior to December 1st of 2019, which was when virtually, if you had a DWI, depending on your blood alcohol level, you were getting suspended. That was it. Didn't matter where you lived. Didn't matter if you were a farmer out in Sussex County with no public transportation, or if you lived in Newark, where you could have public transportation, you had a DWI, you could not drive. Then in 2019 was when the interlock was first introduced for certain types of DWI offenses. Those tier 1s, people could install interlock devices. And that lasted for about 5 years. And then really there was a major shift, a major change in the current DWI sentencing possibilities, and that was signed into law last December and went into effect February of this year, and that's really what we're going to get into. So one thing that we should all know, especially really all of us should know this, whether it's the judiciary or prosecutors or defense attorneys, is it's always important to know when your client was charged with that DWI. We're going to talk about, obviously, cases that have occurred over the past 8 months or so, but many of us have clients that will come to us that have a DWI from 2020 or a DWI from 2018 that they moved out of state that they never dealt with. And they'll technically, the law that was in effect at the time that they were charged is really what controls. Okay, so the new law. There are two real aspects of the new law that we're going to discuss. The biggest one that we're going to get into a little bit later, I'm certainly going to want to have Matai and Hesh and Judge Damiani's opinions on, is plea bargaining. Plea bargaining has been prohibited in DWI cases forever, and now it's not prohibited anymore. And what does that mean? How's the bench dealing with that? How are courts, how are prosecutors dealing with it? Many of us have found that because our entire careers it has been prohibited, it is a little complicated now for suddenly prosecutors to say, wait a second, I do have a little more discretion here, and I do have a little more opportunity in certain circumstances to take individuals' circumstances, the defendant's circumstances into account. And now everything's not necessarily black line. You blow a 0.09, here's your penalty. You blow a 0.12, here's your penalty. You blow a 0.17, here's your penalty. There are now gray areas that prosecutors and judges can consider. Before we get into that, though, let's talk about early interlock installation. All right, early interlock installation basically means, and this has never happened before, but basically it means when a person is now charged and arrested with a DWI, there are circumstances where we as attorneys and where prosecutors and judges can reward somebody for voluntarily putting an interlock device in right away. Okay? In order to get the benefit of installing an interlock right away, there are certain parts of the law that must be satisfied first. And when we talk about early interlock installation, we're talking about installing it either 2 or 3 or 4 days after a defendant's been charged with it, or in other circumstances, maybe installing it a week or 2 before you know a defendant's going to be sentenced to the mandatory interlock. And we're going to talk about the differences in that. Okay, what the law requires is really a handful of requirements in order to get that benefit. First of all, it has to be an alcohol-related offense. What that means is if you have a client or there's a defendant who was under the influence of marijuana or another controlled dangerous substance, they are not going to get the benefit of installing early interlock installation. But that does not mean that not all is lost. Many of us have situations where somebody's under the influence of marijuana when they're pulled over, but first, before giving a urine sample or a blood sample, they do blow into the machine and they blow a 0.02 or a 0.03. Now, while obviously that's not above the legal limit for per se violation, that may be something that you'll be able to use now in a plea bargaining scenario, and we'll get into that a little bit later. Number 2, there has to be no serious bodily injury, except to the defendant, which is somewhat interesting. So basically, if somebody was involved in an accident and another driver, a pedestrian, was injured, seriously injured as a result of that accident, they do not get the benefit of putting an interlock in early, unless they themselves were seriously injured. So it's a one-car accident. The defendant seriously injured goes to the hospital. You can still advise them in certain circumstances to put that interlock in, and they may get a benefit. Next, the defendant cannot be suspended at the time that they are arrested for the DWI. Now, it says that they cannot be on the revoke list to get that penalty, to get that benefit. So interestingly, even if somebody is revoked because of an unpaid parking ticket or an unpaid surcharge to the state of New Jersey, unfortunately, that minor technical administrative reason for their revocation is going to prohibit them from getting the benefit of early interlock installation. They must have a valid New Jersey driver's license. So if they are from another state, if they're from New York, Pennsylvania, any other state, there is no reason to tell a client to install an interlock device, except what I have found, and all of us I'm sure deal with at times, where you do have a person who is residing in New Jersey and has been for some time, but they still have an old New York license. It may be beneficial, depending on how long they've lived in New Jersey, to suggest to them, in fact, in many cases I do, why don't you now get your New Jersey license? And there's going to be a lot of reasons that you want to do that. One, if you put the interlock in, we may be able to get some benefit. Two, if they have a New Jersey license at the time that they're sentenced, they won't have to deal with what happens in New York as well. I practice in New York as well. And if you have a New York license, you're going to deal with your New Jersey penalties. You're then going to have to deal with your New York penalties. If a client surrenders their New York license and only has a New Jersey license at the time of sentence, it is very unlikely New York will ever find out about it. And even if they do, because they're no longer a New York licensed driver, they're not going to have to deal with that as well. Okay. Let's talk about briefly what the provisions now of the new law are. Basically, in February 19, 2024 is when this law went into effect, and that voluntarily installing an interlock device is now something that people can consider. All right. Now, here's the reason that there are certain benefits to doing that. First, the court may, upon conviction, eliminate a fine and or reduce a person's period of license suspension if they have installed the interlock device. First, let's talk about eliminating the fine. If somebody is going to be a tier 1 or even a tier 2, where basically they're not going to get suspended, they're only going to be suspended for that 1 day or 2 days until they install the interlock device, if we are at a place where we have resolved the case with the prosecutor and we know that they're going to be a tier 1, they're going to have a 90-day interlock installation. In that circumstance, I advise clients about a week before to go to Jason, to go to Interlock of New Jersey, put the interlock device in. You're going to get several benefits for that. One, at the time of sentence, it's already going to be installed. Two, at the time of sentence, you may ask the court to eliminate the $300 to $500 fine because you have now done the early interlock installation. Judge Damiani, have you had people who have taken pleas who have already installed the interlock device when you're taking the plea?
I have, and I have really not had any defense counsel ask me to eliminate the fine or reduce the suspension. I think that is an area that the defense may want to step up. I'm not going to voluntarily offer it, but it has not been requested of me. And I would then gauge the situation on a case-by-case basis, but I'm glad you brought that up. One other thing I'd like to, before going further, I think a lot of defense counsel are also confusing the not being on the revoke list. Some of them are trying to tell me if it's an administrative revocation, it shouldn't count. I don't believe that is so. What is your opinion, Warren?
So, I mean, the law's pretty clear on it that if it says you were on the revoke list, it doesn't say except for an administrative revocation. So to me, if they're on the revoke list, I think they can't take advantage of this.
I go the same way, but a lot of defense counsel are trying to tell me that if it's a parking offense or so, I tell them revoked is revoked.
Yeah, yeah. And I will tell you that I also sit in court, either in Zoom court, and I see so many defense attorneys say, Your Honor, my client's already installed the interlock device, here's a certificate, and I'm waiting for them to say, and therefore, under the new law, Judge, I'm asking that you consider waiving the $300 to $500 fee. And like Your Honor said, I have never seen it happen.
Nope.
And it does frustrate me, and I'm glad people are here, and especially if there's defense counsel that's here, that the law was changed to give your client the benefit. And if they're installing the interlock a week before, and they may be entitled to it, and again, the law says may, the court may decide not to, but certainly you should ask that question.
Agree.
And I don't know, Mate, maybe you tell me. I don't know, as a prosecutor, when a defense attorney says to you, "Hey, my client has put the interlock in," and I know I've said that to you many times, and I know other defense attorneys have as well. Do you ever say, or would you ever say, "Oh, do you want me to put on the plea sheet minimum fines and penalties, consider waiving," or do you think that's really defense counsel's obligation to do that?
I do think that that would have to come from defense counsel. And I would say in all candor, I would, probably not be inclined to waive it.
Okay.
At least on my side.
And I'm curious why, if the law says it, and if somebody has gone out and they've, under with the advice of their counsel, they did put the interlock in, and they did surrender their regular license, and they now have their interlock license, which in fact does technically save them having to go back to DMV because they now have their license. Why do you think that somebody shouldn't at least save a couple $100 off of the fine?
I think it would depend on the circumstances, but in all likelihood, I will say that I have seen a very significant change in the law. So I think that the person today is already getting a lot of benefits. So it would depend. I shouldn't say I wouldn't do it. I take it on a case-by-case basis, but I would say that I'm not inclined to agree to that.
I understand.
It's
So
Joe. Yeah, I have a couple of comments. First of all, the waiver of the fines incentivizes people to go out and do this. So that's, I assume, why the legislature did it. They want people to do this. It's a desirable outcome. So I would encourage the judges and Maite and Hesh and the prosecutors to at least consider it, because it's a good thing. I think the legislature has declared it a good thing by passing this statute, but it's hard to change things. That's part of what we're going to talk about in a little while. The other thing is, Warren, I'd ask you, and again, I'm an observer, basically. I've only handled 8 or 9 of these, as I've repeated. But isn't there, Warren, within motor vehicle jurisprudence, if you will, a distinction in some areas between administrative revocations and substantive revocations? I heard that come up in my short career as a defense lawyer in the municipal courts. That administrative are different.
I mean, absolutely. I mean, most administrative suspensions are a result of, as I said, unpaid parking tickets, unpaid insurance surcharges, things like that. So yes, there are administrative suspensions that cause somebody's license to be revoked. Many times, those are the people who aren't even really aware of it. They got a parking ticket, kind of forgot about it. As I said, the way the law is drafted, it certainly says if you're revoked at the time, you cannot take advantage of the early interlock installation. As an advocate, I probably would still argue for it if it was just a technicality, and at that point, leave it to the judge to make that decision. For first-time DWI offenders who are going to be getting the penalty of an interlock and not a suspension, really what we're arguing about is the $300 to $500 fine. We're going to get into circumstances where people can get a true benefit, a reduction in their suspension. And certainly something like that, I would probably make even a more zealous argument to try to get that, and we'll kind of get into that as well.
And Warren, someone is asking, Natalie is asking, what is the approximate cost to install an interlock?
Yeah, I'm sure it's my friend Natalie Candela. So, Jason's going to get into that. And again, Jason's company is excellent. I actually think they're the most reasonable. And Jason, maybe you can even jump in real quick. But if I remember, your company, I should be careful, but I don't think you guys charge for installation, do you?
No, we don't. And it varies significantly. So I don't want to take up too much time with that right now. I did answer in the chat what a basic price would be.
That's great. Yeah, definitely when you go, you'll talk about all of that, but thank you. Okay, and then the other thing, the other requirement, just continuing here, is that they do have to have a valid New Jersey license at the time. So again, if you have an out-of-state driver who's truly out of state, lives out of state, you know, probably no reason to tell them to put an interlock device in before they're sentenced. Okay, now here's kind of the biggie, and this is really a big change in the law. If you're going to have a client who is going to face a mandatory loss of license. So we're talking about a first-time offender who blows above a 0.15 and above is going to lose their license for 4 to 6 months, right? We're talking about a second offender who's going to lose their license for 1 to 2 years, although most of the time it is just that 1 year. Or a third offender who's going to lose their license for 8 years. These are the category of defendants that we want to talk about this advantage to installing an interlock device. Now, let's get into a little bit because they really are different. If you have a first-time offender who blew a 0.17 and a 0.18, they're going to lose their license if convicted of a 0.17, 0.18 for 4 months. Now, if as an attorney they come into your office and you suggest to them, hey, if you put an interlock device in now, and for whatever reason, your case takes 8 months to resolve because of the court's calendar, because of motions, because of whatever else, you could, at the time of sentence, receive no suspension whatsoever. Because if your device is in for 8 months and the court gives you 4 months credit off of your suspension, they can get no suspension whatsoever. Now, here's the question that I have. As a defense attorney, I'm sitting down with a prospective client. It is very difficult for me to say to them, well, we're sort of going to throw the towel in right away. You know, if you're convicted of a 0.18, we're kind of hedging our bet right there. So it is a challenging discussion to have for a first-time offender because you are almost acknowledging to them right then and there that we're just going to roll over and our strategy is going to be to, not going to say delay, but to have the case take as much time as possible. So I can tell you from my perspective, I almost never suggest that a first-time offender install an interlock early. And the reason for that is because I'm going to fight that reading. I'm going to go through the videos. I'm going to go through all the paperwork. I'm going to look at whether there was an uninterrupted 20-minute observation. If necessary, when I conference the case with the prosecutor, I'm going to suggest that I'm going to send those types of cases over to a expert to take a look at to see if there is a question that we can raise about that reading. And if I'm working on that, and if ultimately we resolve the case where either a prosecutor stipulates to a 0.14 or maybe they stipulate to having the conviction based solely on observations, then what am I going to do? Once I know that's going to happen, about a week before, I will tell them to put the interlock in the hopes of saving the fine. But I have not, from the get-go, suggested that, hey, you know what? Put the interlock in and let's kind of worry about it 6 or 8 months from now. Matai, do you still find, even now with the new plea bargaining possibilities going on, when you have somebody who is in that third range above a 0.15, are you still talking to defense counsel about, you know, get an expert report, point out to me issues that could question that reading?
I guess it depends on the case, right? It depends on what kind of legitimate basis they have beforehand. There's some where you're still going to need that expert report. But if it's a case where they've given me significant information beforehand, and I'm talking medical records, and I have seen one at the very least that I recall that didn't require the expert.
Yeah. And what I find, again, I think any diligent attorney who's really going through the evidence, and particularly those body cams, often we can find breaks in those 20-minute observations. Hesh and I had a case, Hesh, if you don't mind me bringing it up, not too long ago, where the entire 20-minute observation was on the officer's body camera, but there were twice that he was called out of the room, so I saw him leave the room right on camera. And you know, I pointed out to Hesh, you know, who is always open to obviously look at what the evidence shows, and he agreed and spoke to the officer about it. And the officer said, "Oh, you know, you're right. I think my sergeant called me out for a minute." Certainly, there was no need for an expert report when it was right there on video. And I think that there are many times now with those body cameras that you are going to capture breaks in those 20-minute observations. And certainly, Mate, if you were to see, obviously, video evidence of it, you would certainly be open at that point. I would think
Yes.
to,
I mean, the case is a case at the end of the day, of course.
case is a case, of course. Yeah. So again, when we're talking about those first time offenders above a 0.15 who face the possibility of a mandatory suspension 4 to 6 months, that's at least the approach that I take on those, is that generally I am not going to tell them to put an interlock in. Now, somebody blows a 0.25, a 0.27. All right, now we're getting into an area where unless there is a real issue with that BAC, I'm probably going to say to a client, it makes sense. Let's hedge our bets a little bit. We're still going to try to fight this thing. But worst case, you put that interlock in and we know we're getting some credit there. Now, for a second offender, right, we're dealing with somebody now who is going to have a mandatory 1 to 2 year loss of license. When I deal with second offenders, I do not think at all that it's going to appear that I'm not going to advocate for them. But when they come in, I tell them, let's put that interlock in right away. There is no harm in putting it in right away, because worst case scenario, they spent $500-600 having an interlock in for 5 or 6 months. And by doing that, maybe I've reduced 1 year loss of license down to a 9-month loss of license. Best case scenario, we end up finding real issues with the case. Ultimately, maybe we're successful. Ultimately, maybe we plea bargain it for some other reason. We could talk about that. And best case scenario, they end up with no suspension. But to me, on a second offender, there is no reason not to have them get that interlock in right away. Jason, if I can just ask you a question, could you and I have dealt with a couple of these now, right? One of them may have been one of the first ones that we dealt with. I think I had somebody come in and hire me on a case around March 1st, and right away I said, put the interlock in right away. And he said he'd spoken to other lawyers, and nobody had even mentioned that. Immediately I got Jason on the phone, right? And we sort of worked through that one. So, you know, Jason, if you want to just a little bit, maybe here's a good place to jump in just about what that process is when we have somebody do that early interlock installation.
Sure, and I'd like to walk through the process more thoroughly a little later, but there is a bunch of paperwork and a lot of movement that your client has to do back and forth to motor vehicles, to the service center, back to motor vehicles, where there's paperwork that they need to get from us to bring to them in order to get that that restricted use license that they're going to use.
Right. So again, for a second for a second DWI, again, my approach generally is I'm still going to advocate, but there is no reason not to hedge my bet and have a client put an interlock in.
Warren,
Yes.
just for edification of defense counsel, I don't know about other courts, but I've not yet had any attorney ever ask me for credit on second offenses of having had interlock installed. So I think that should really go out to defense counsel, because that has, and I have a great deal of DWIs as a result of Route 80 going through my town. I have never had anyone ask for that.
Right. And Your Honor, you know, look, again, that's frustrating to me, because this part of the law, it doesn't say that the court may waive a fine. This says that the court shall give credit. So, I mean, this is black and white. All an attorney has to do is ask for it. And I don't care if a client put it in a month before. Then the court shall give them 2 weeks credit off of their suspension. That's it. But of course, if a counsel's not going to ask, then your honor's not going to do it. And again, that is frustrating. And that Mate, is something that I always say to the prosecutor. I have one right now, a second, where he has had it in. This is the one Jason and I were talking about since March, and he's going to plead in January. So that's going to be, what is that going to be, about 7 months? So instead of a year, he's going to end up with a 8.5 month suspension. To me, that's a very good outcome. So Matai, have counsel said to you, hey, my client's a second offender. I know it's a year. He's had the interlock in for 7 months, 6 months.
I have never seen it.
Well, I'm glad we're all here. I'm glad we're all here. All right. So now we know this is the law. And again, this, law says shall, doesn't say may. So when it's brought up with a municipal prosecutor, again, this is something you simply say, hey, look, client's had it in for 6 months. I'm going to be asking for 3 months off of the suspension. Prosecutor's going to say, hey, that's the law. Make your argument to the judge. Truly, it's not even really an argument, it's just a sentence at that point. I'm just going to throw in real quick this one new part. Thankfully, I've actually never had this in my career. And this is where a commercial driver is actually driving a commercial vehicle while they are intoxicated. That's a really scary thing. It's actually very similar, I think, to pilot's license. That if somebody is driving a commercial vehicle and they have a 0.04 or above, that they are going to be suspended. Their basic driver's license is going to be suspended. They're going to have to put an interlock in, and their commercial driver's license is going to be suspended as well. And again, this is not a commercial driver driving their own personal vehicle. This is a commercial driver driving a commercial vehicle at the time, and they have a 0.04 or above. So again, just one little provision that was amended. I have never seen a commercial driver charge while driving their commercial vehicle. Okay, let's get into plea bargaining a little bit now. All right, so I'm going to talk a little bit about the background, how we got to now we can, quote, plea bargain these cases. And when we were talking yesterday, plea bargaining does not, in my opinion, always mean I'm asking for a dismissal. In fact, most of the time, I'm not asking for a dismissal. Plea bargaining can have a wide range of options for us that never existed before. But let's get into it a little bit. Okay. Under Municipal Court Rule 7:6-2D, plea bargaining years and years ago was actually prohibited in municipal court. You could not plea bargain in municipal court. The Supreme Court got involved, and this rule was developed that then did allow plea bargains to take place in virtually every case in municipal court. And those of us who sit in municipal court and have thousands of times, when we hear those opening instructions from the court, the judge always mentions that plea bargaining is allowed, but there has always been this language that says in certain drug-related or driving while intoxicated offenses. Maybe that language needs to be removed from the opening remarks now, but plea bargaining has been allowed in all cases forever, except certain drug-related and alcohol-related offenses. And the prosecutors have always taken into effect the fact that they have to have jurisdiction. So obviously it has to be a case that has come back down from the Superior Court. And the prosecutor, if they're going to plea bargain, always represents, I spoke to the victim about it. If the victim's present, I've explained to the victim. The law requires that the prosecutor consult with the victim, not that the victim has to agree. It is ultimately the prosecutor who decides, but that they have spoken to the victim, or the victim's been notified and didn't show up. Maybe they've spoken to the arresting officer. And all of that has to be taken into account. And I certainly have seen Hesh and Matai on virtually every occasion when there's a plea bargain in any type of case, they'll represent to the court, hey, yes, I spoke, and we're not talking about about DWIs, but Yes, I've spoken to the prosecutor. I'm sorry, I've spoken to the police officer about this. I've spoken to the target security officer about this, and we are going to downgrade it to a municipal ordinance, whatever that is. In a domestic violence case, I've spoken to the victim, and they consent to us putting the case on hold for 6 months while the defendant does anger management. So prosecutors always do that. Mata, you'd certainly agree that in those types of cases, right? Certainly always talk to the victim if they show up for court, right?
100%.
And that and not only do prosecutors do that, I mean the rule actually requires that they do. So now, again, for most of our careers, there's always been this exception, which we've all called Guideline 4. Guideline 4 has always said, a guideline put out by the Supreme Court, that no plea agreement whatsoever will be allowed in driving while under the influence of liquor or drugs. So the Supreme Court said, I know what the rule says that was enacted by the legislature, but we are putting out guidelines to all prosecutors that there will be no plea bargaining whatsoever in DWI cases. Now, Matai, prior to the law changing, would you think when there was a question about a reading that we talked about, and defense counsel does hire an expert, and the expert says, you know what, I know the reading is showing a 0.16, but I've looked at the video. It looks to me like there's a break in the 20-minute observations. I've looked at the machine itself, and it looks like that there was an issue with the machine, whether it was a 2-minute lockout, whether it was problem with the tolerance. In the past, if a defense attorney brought that expert report to you, and the goal was, instead of a 0.16, my client will plead guilty based on the observations of the officer, or maybe even we stipulate to a lower grade. In your opinion, would you have considered that a plea agreement? Or would you instead say, well, it's not really a plea agreement. It's more that there's a weakness on this aspect of the case. So I'm not doing a plea agreement, but instead, based on the evidence, we're coming up with a way to resolve a case.
I would say, just like I said before, a case is a case. If I cannot prove the case because there is this deficiency, then I'm not going to waste everybody's time. But I'll put it on the record. This is the reason.
Right. And there have even been times, and I don't recall if you and I have done this, but there have been many times in the past when I presented an expert report, and the prosecutor and myself actually enter that report at the time of sentence as a joint exhibit. Judge Damiani, in the past, had you had that occur where that report was actually presented to
Yes.
your honor? Yeah.
Yes, but I go one step further. I have the prosecutor first put his factual basis on the record, why he believes it should be not a lesser, say the observation, the 20-minute observation, but I also have the officer present and ask if he was consulted, and if he finds this to be a fair resolution, making it a point that his answer does not control my decision, but I want to make sure he participates in the process. So anytime there is a basis upon which to give a lesser penalty, I always have the prosecutor put his basis on the record, and as well as the officer.
Mm-hmm. Right. And sometimes I have found over the years, and most officers are completely fine, especially if a client's going to be pleading to a DWI, and if their consequences will be slightly less. But it can be a little bit uncomfortable when the reason for that is because you're saying, you know, officer, I did look at your body camera. You did step out of the room for a few minutes. In the report, you said it was an uninterrupted 20 minutes, but you kind of have to acknowledge, maybe you didn't recall, but actually it was interrupted. And again, most officers, I actually have found most officers are fine with it and take it as almost like a learning opportunity. And they realize, you know, everything is being recorded. So if they're going to step out of the room, they better have another officer step in to make sure that that 20-minute observation is maintained. So So what was always very frustrating for defense counsel, probably not for prosecutors, but it was always frustrating that we always said, well, how can the court interfere with a plea bargain? It's on a DWI, because it's really, it's the prosecutor. The prosecutor is the one who has the right to evaluate the evidence in the case and decide, is the evidence strong? Are there some weaknesses? Can I work out this case in a way that society is served, that I fulfilled my obligations as a prosecutor, that there are certain consequences to the defendant? Why, as a prosecutor, should the judiciary get involved in stopping my ability to do that? And the reason that the courts get involved is because the courts say so. And back in the Constitution, the Supreme Court, in our Constitution that was enacted in New Jersey, the Supreme Court put in that they shall make rules governing the administration of all courts. And what the Supreme Court has interpreted their own language to mean is that plea bargaining is not a right of a defendant, and that the court can restrict plea bargaining because they're doing it as part of governing the administration of court. And that takes place in brimage cases to this day, right? There are certain limitations on, right, Joe? Right?
Yeah.
I mean, the Supreme Court's saying, hey, in brimage cases, I don't care what the prosecutor wants, there are limitations. And we are saying, here is what you are allowed to plea bargain. We as the court are telling you that as a prosecutor, right?
Yes, Warren, and this is something that came up in my career as a prosecutor time and time again. And you would think I have a prosecutor's perspective, and I think I do. But there's nothing more self-serving than the brimage decision by the courts. In this sense, they're making the final determination about who has the authority to interfere in plea bargaining or interrupt plea bargaining or interfere is what the slide says, or have input on plea bargaining. So, they're making the rule and making a decision about their own interests. So that's why I say it's self-serving. But I look at it this way. I don't deny that the courts have a role, because there are constitutional aspects to this question. There's no doubt about it, right? Separation of powers. So how does the court have the authority to get in the middle of the prosecutor's process, right? The executive branch here. And I think from a constitutional perspective, not to get too far afield, the 14th Amendment guarantees everybody due process, right? And the fundamental fairness. So to that extent, the courts, I think, have the right to look at plea bargaining from the perspective of what's fundamentally fair, what does due process compel? And in that situation, the prosecutor can be arbitrary at times, or can, come up with a plea bargain that's not fair, or that doesn't take into account all the myriad interest in plea bargaining. On the other hand, the administrative explanation, I don't find that as persuasive, but I don't make the rules, they do. I think it's really a constitutional analysis rather than an administrative analysis. And just to wrap up, I think if our position is, and I don't do a lot of these, and Maite and I are close, and Hisham is close, and I know a lot of attorneys that prosecute these cases, and I'm not in the municipal court that much, but if the standard is whether we can prove the case or not, then nothing's changed. Because as a prosecutor, you have an inherent obligation to resolve a case and to prosecute a case based upon whether you can prove it or not. If you can't prove it, justice demands that you not prosecute that count, right? If you can't prove it, then that count should not be prosecuted. That's an inherent obligation of a prosecutor. So what I think plea bargaining now allows us to do is to look at other aspects to whether we can prove it or not. It requires us to look at, if I was the prosecutor, and I think it requires prosecutors, to look at other aspects, the person's prior record, the nature and quality of the arrest, their level of cooperation, all the things that we look at historically as to whether the accused should get a benefit when the case is resolved. And whether we can prove it or not is the way we used to do it, because the Supreme Court said you can't plea bargain. So that was a good way to resolve the case and be respectful of guideline 4. But now that there's no guideline 4, whether you can prove it or not is more of the same. I think you need to look at other factors. If you can't prove it, you ought not be prosecuting it. And that's coming from a former prosecutor.
Great. Judge Damiani, let me ask you something, because I've had this happen where a prosecutor and I have come up with what we'll call a plea agreement. And we go before the court, and the court, after hearing it, says, you know what, I'm not going to accept that plea. And Your Honor, have you been in that situation at times?
I have.
Right.
Not
So-
not often. I listen to both sides, but there are some times that it is just against my principles that the plea that's being offered is not does not rise to what should be the effect. I let them modify it. I'll have them go out and work at it again. But there are sometimes I feel that it is just too lenient in light of the prior of the facts that are presented. It's
Right.
something that doesn't sit well with me, not for any other basis other than I don't believe it is appropriate for the charges that are being assessed.
Right. And it rarely happens, but it does, right? Sometimes you go in front of the judge and you go in front of the court and they don't agree. And the dilemma then for defense counsel is, well, now Your Honor has heard that my client wants to plead guilty. And the court has said, you know, I'm not comfortable taking this plea. Now the issue is, well, if Your Honor's not going to take the plea, my client now wants to go to trial. Do you think in that circumstance, because Your Honor has heard that the person wants to plead guilty, would that be a case that at that point Your Honor would say, if you want to do that, that's fine, but I think you need to send it to another court because I've heard your client's intentions? Or do you think that the court still has the opportunity to be fair and impartial at that point?
Yeah, Warren, I think if the judge is doing their job conscientiously, until hand is put on Bible or oath is taken or affirmed that nothing heard previously to that has any bearing whatsoever. And sometimes I understand that defendants will take a plea to be done. But if the plea is not acceptable to them, then they must go forward with what they believe is their fair case. If a judge is doing their job properly, again, until the evidence is presented, until the testimony is given, nothing said before that should have any impact whatsoever. I don't believe it needs to go to another court.
Right.
And Warren, I couldn't agree with the judge more for what my 2 cents is worth. This happens all the time where judges hear information that certainly goes to the ultimate outcome, and they're supposed to divorce themselves or separate themselves. It happens in juvenile court, sometimes happens in superior court. And I couldn't agree more with Judge Damiano. I would say this to the judges, if there are any other judges besides Judge Damiano, and take whatever legal advice this is for me for what it's worth. But if you're uncomfortable, judges, accepting a plea, I think what we should do is have an articulable basis. Now, you don't have to tick off 5 reasons why you're uncomfortable, but just to say you're uncomfortable, borders on arbitrary. There's always a reason why you're uncomfortable. Make it articulable, put it on the record. And I know you probably do that, whoever the judges are. And I've seen some people who sit in other courts in the gallery here. Just put on the record why you're not comfortable with it. And you know why. Say it.
I agree with you, Joe. I believe that you owe that to the attorneys, to the prosecutor, and to the defense counsel, and give them a reason to go back to the drawing board. And they may come up with a solution that may be satisfactory to everyone as well as the court.
Great. All right, Joe, what I'm going to do is I'm going to get into a little bit of the judicial back and forth that happened once the legislature. I'm going to do that maybe for 5, at most 10 minutes. Then at that point, I'm going to turn it over to Jason because I know people are really interested in seeing how this device operates and what the process is. So I'm going to try to move this along pretty quickly, just a couple of slides left. So plea bargaining. All right. So in December of last year, the legislature amended the DWI law, where it now said, notwithstanding any judicial directive to the contrary, upon recommendation by the prosecutor, a plea bargain under this section, under 39-450, is authorized under the appropriate factual basis consistent with Title 39. So now the legislature in black and white was saying, we know the Supreme Court put out this guideline. We are now overruling that as a legislature. We are putting language in place that says plea bargaining, plea agreements are now allowed in DWI cases. All right, so what happens, right? Almost immediately, actually 2 days before the law is supposed to go into effect, Administrative Judge Grant puts out a memo to all municipal courts, and in that says, if a challenge to guideline 4 is raised in any municipal court case, please immediately bring that to my attention.
Iggy Pop. Iggy Pop.
So when prosecutors and courts receive that memo, and Judge Damiani, I assume you recall getting that memo a day or two before this came out, that certainly put a hold on anyone's thoughts that there was going to be any plea bargaining occurring in DWI cases. There was an anonymous state legislature quoted in the Star Ledger when this memo came out that said, and I'm just quoting here, Grant isn't even a judge anymore. He's just a staff guy now. When did staff guys get the legal authority to simply toss a law? That was an anonymous quote, obviously, but the legislature, I think, was frustrated that they had passed this law and the courts were getting involved in trying to stop it. And 2 days later, Chief Justice Rabner put out what we will call an advisory opinion. And basically what he said, in summary, is that the court still has the right to regulate plea bargaining in municipal court. It is still an administrative function, and we have the right to do that. And that the court over the years has always limited the ability to it. And the court still has the ability to limit this. However, basically, the Supreme Court said that this new law has a constitutional question. There's no actual case before the court, but we as the court recognize that this amendment reflects what the legislation wants. It's been written into law, and because the court wants to cooperate with other branches, it does not serve either the judiciary or the legislature to gauge in a back and forth in a test of power, and therefore we are eliminating guideline 4. So this law gets signed by the governor in December, scheduled to go into effect in about a 48-hour period. There's a lot of back and forth going on, and all of us are watching. And then ultimately Judge Rabner said, hey, we still have the power to do this, but we're not going to get in the way, and guideline 4 is now gone. With withdrawing guideline 4, now there is no prohibition in DWI anymore, okay? So what that means, and again, I'm going to do this in about 2 minutes. Basically, what that means is now a prosecutor, Matai, what you had done before, what you've always done over your career, every time we've always been together, is you've always looked at every case individually. But now I think there is a little more room for plea bargaining. And again, when we had this discussion yesterday when we were preparing, plea bargaining does not mean a dismissal. It does not mean that every defense counsel can walk in on every DWI case and say, oh, well, you're allowed to plea bargain now. Can you dismissal? Let my client plead guilty to careless driving. I think counsel loses credibility because if the facts are still there that warrant a DWI conviction, then they are still there. But if there are certain circumstances where a conviction can be based on observations, right? Or what I have found, and what has happened in several cases now, is there are times where somebody has a refusal and a DWI. In the past, they had to plead guilty to both. Now they don't have to anymore. So maybe on a first offense, sometimes, especially for out-of-state drivers, it may make sense that they plead to the refusal and not the DWI. Would you call that a plea bargain? I don't know. They're still getting consequences. They're still having an interlock required. but for their home license, that may be beneficial. So there are times like that when that can happen. There's one other thing that I have found a couple of courts doing. I actually mentioned it to Judge Damiano yesterday, and that is what I like to call a wet reckless. Jason and I have spoke about this previously. If I have a client, and I have had clients who blow a .08 or a .09, and it's a first offense, and there was no accident, and they were cooperative, and they look very, very good on the video, I have suggested to prosecutors that this is a case that may be right for what I call a wet reckless. What a wet reckless is let them plead guilty to a reckless driving and still put an interlock device in for 90 days. And someone who blew a .08, it was a borderline reading. They're still getting a consequence. Society's still being protected by having that interlock in. However, they're not having a DWI conviction. They're not going to have that $3,000 surcharge. And I think there are those type of circumstances where plea bargaining now has freed up a prosecutor's opportunity to do that. And Matai, I'm sure when I present that to you in a situation, you're going to say, Warren, I agree with you. This is a case that I am going to use my powers. I am going to plea bargain, and maybe we'll have a case like that in the future. With that, all right. So we have about 25 minutes left, I think, Joe, to get to the hour and 40 minutes. Now, Jason, I do want to turn it over to you. I know people are really interested to see how this device operates, and I appreciate everyone listening to me. Maybe we'll have some questions at the end, but at this point, let's turn it over to Jason if that makes sense to everyone. And you can take me away from being a co-host now. Thank you.
Thank you,
All right,
Warren.
thank you, Warren. That was great. I'm just, I know that there's not a whole lot of time, and I want to just kind of hit the high points and give you guys an opportunity to ask any questions about processes. So I'm going to just briefly go over some background stuff and then the process for having the device installed. So that you guys understand, I'm one of about 10 companies approved in the state of New Jersey in order to install and service interlock devices. The manufacturer that I use is Draeger, which we're all familiar with. So there are about 10 manufacturers approved in New Jersey. We are the distributor for Draeger. And then each of the other manufacturers have some other device, whether that's the Smart Start device, the Intoxilock device, and then there's other names of devices along the way. This here is what an interlock device looks like. This is the Draeger interlock unit. The software that's running on the background of this is very similar to the stuff that you would see for the Alcotest, and it uses the fuel cell that the Alcotest uses. In fact, all interlock devices use fuel cell technology as opposed to, and solely fuel cell, so there's no IR or anything like that. And what it essentially does is requires the user to take a breath test prior to being able to start their car. We install the device into the car's ignition system, which means that it doesn't have the ability to shut an engine off if somebody were to fail a test. But what it can do is prevent the vehicle from starting. And being that there's 10 manufacturers approved in New Jersey, each manufacturer has a network of service centers. So for example, Draeger or myself, Interlock Device in New Jersey, has 10 locations throughout New Jersey. One of the other companies may have 50 or 40 or 5, but altogether, anybody in the state of New Jersey can find a place fairly close to them that they can install a device, in that there's probably about 100 to 150 approved ignition interlock service centers. Now, Motor Vehicles is the agency that oversees us. They are the regulatory body, so they make the rules for us and tell us what to do. One of the questions that came up in the chat was the cost of the device, which I'm sure is very important to all of your clients. And that cost, I wish I can give you a better answer, but it's going to vary significantly between company to company. Some companies are going to charge installation fees, removal fees. They're going to charge some sort of rental fee. There's services that are periodically required by Motor Vehicles that we have to do on the device every 60 days, and some companies can charge for those as well. And some will charge higher installation fees, lower service fees, back and forth, so on and so forth. What I want to make clear is that if a company charges an installation fee, the longer they have the device, the cheaper the price becomes. So for example, if you have a brand new Mercedes that company is going to charge you $500 to install it, and you have a 90-day sentence, that $500 is a much more significant portion of the cost than if you have a 2-year sentence, which brings the monthly cost of the device down. But overall, if you're going to have it for an average period of time, say a year, you can pay anywhere between maybe $120 a month to maybe $160. But again, that number can get significantly higher if you pay a really high installation fee and you only had it for 90 days. What we like to do, just so that it's simplified, and because we're like more independent and not a national company, is we charge a flat fee of $4.25 a day, puts the cost around $120 a month, and then we don't have any of those other fees. So theoretically, if you come to us, you might be able to find somebody cheaper if you have it for a really long period of time. And that's just a calculation that the customer has to make. But I want to make sure that I'm being transparent with you as far as how the cost works. But if you were to say $120 to $160 a month for the interlock device, you'd be in the ballpark with just about everybody. Pre-installation conviction is a very new thing. There's a very specific process that the client has to follow in order to get the proper credit for that, and also have the proof that they need when they walk into court to show that they've had the device on. And when you tell a client to have the device installed, they would call one of the providers, schedule an installation appointment. And it's important to note, they must bring the ticket with them to the installation appointment. Either they can bring the actual ticket, or if you guys do the printout from the state website, or they do, and bring that with them, that would suffice as well. But motor vehicle says we are not allowed to certify the installation unless they show us the ticket. Warren had mentioned some preclusions to early installation, and those were things like bodily injury, being on the revoked list, and having a valid New Jersey driver's license. The installation company is not checking for any of that. Motor vehicles, so you know, is not checking for any of that. Motor vehicles is relying on the court to ultimately make the determination. So you don't want to have your client put it on, have it in for a couple of months or weeks or whatever, pay for the device, only to find out that the court realizes by looking at the abstract that they don't qualify, and that's kind of a wasted time for them. So make sure that, if you want to help your client out as best as possible, do that research with them prior to calling us, because they have not put that on us to check. And motor vehicles says that they're not interested in checking that as well. Once they make that appointment and they come in for installation, which will take approximately an hour and a half to 2 hours, we will give them hands-on instruction and video instruction as to how to use the device. Again, those are regulations required by motor vehicles. When they leave us, if they have the ticket, we will give them what's called a pre-conviction installation certificate. They will then have to, within 7 days, if you guys have read the statute, it talks about this 7-day rule. Within 7 days of installation, they will need to take that certificate to motor vehicles. When they get to motor vehicles, they go to the restoration desk, at which point they will provide them with they will take their license and provide them with a restricted use license. And essentially what that means is just a regular driver's license, but under the restrictions section on the license in red, it'll say interlock device. And that's what's to indicate to any officer, should they get pulled over, that they should not be driving a vehicle that does not have an ignition interlock device installed.
Iggy Pop. Iggy Pop.
Post-conviction, you've made your plea, or the case is disposed of, the court will give a order and certification to your client. And this is the piece of paper that back when all courts met together, the client would go to the window and the court clerk would hand them. And it's kind of a grid, and it says IDRC and the amount of time, 7-month suspension, so on and so forth. They'll need to send that into us once they receive it. They can simply email it to whoever their contact is at the provider, depending on which provider they use. And we'll give very clear instructions on all of this. With that order and certification, it's best practice for your client to return to motor vehicles with that order and certification. And they will notate on their abstract that the interlock device is installed, and that is the portion that's going to begin their sentence. Now, 50, maybe even more than 50% of the time, motor vehicles has been on top of that and will enter it into the computer the moment it comes through the ATS system or whatever system it is they're using today, but it's not 100%. And what I'd hate to see happen is a client who is not getting credit for time that they have the device. So if you want to be very thorough and make sure 100% of the time that they're getting credit for their time, get us the order and certification, return to motor vehicles, and make sure.
And Jason, you know, one other thing, the client has to pay their restoration fee right away. So when they go down to DMV with your certificate and with the order and certification, they have to pay, it's $100 restoration fee and $100 DDP fee, $200. If they don't pay that restoration fee, I have had clients not get credit because even though they put the interlock in, they didn't, quote, restore their license yet. And I don't know if you've had this where clients have come 90 days, hey, they're like, hey, I'm ready, let's take it out. You contact DMV and they're like, they have 0 days credit for an interlock device. So I don't know if you've had that, but I tell clients, you go down and when you get your restricted license, pay the restoration fee.
Thank you. Yeah, no, and we don't necessarily have that because we walk through every client through that process, but we are super, super familiar with New Jersey since we only handle New Jersey. But should they go to another company where they're subcontracting to somebody in New Jersey, they vast majority of the time, and I'm not trying to be pejorative of the other companies, if they're the one they want to go with, go, but they're not going to give them that level of direction, and it's going, just because they simply don't know. They have a lot of states they're dealing with and different rules, and they really put the onus on the client. And so we'll walk them through all of that stuff. But yes, just so you guys are aware, so you can direct your clients appropriately. During the, so there's a back and forth. Now, if it's, I don't even know if I need to talk about post-conviction, but if there's somebody who doesn't fall under the new law because the case has been hanging around, it's a similar process, but it's not as many trips back and forth. And if you have any questions on that situation, I'm more than happy. You can reach out to me anytime. They're going to have the device. They're going to be required to come in for those regular service appointments. At the end of that period of time, within the last 30 days, there's a monitoring period that we will make them aware of, but you might want to make sure that your clients know that the only time they can get in trouble for blowing a high BAC, missing a retest, that sort of thing, is in the last 30 days of their sentence. We let them know, and also by giving us the order and certification, we know when we're allowed to remove the device and when the last 30 days starts. Within the last 30 days, when they come in for their final appointment, we will do a data download of all the information that's stored on the device, which is an incredible amount. Every time the car was turned on, every time the car was turned off, every test that was taken, so on and so forth. If in those last 30 days, we'll download the information, we'll send the client on their way, and it'll be on the 31st day, so that we have the entire last 30 days, send the client on their way. Within 24 hours, we will present them with a certificate of compliance. Now, we have two options on that certificate of compliance at first. The first option is they've complied with everything, which is in the last 30 days, they've had no high BACs, they haven't missed any retests, and they've complied with all the maintenance requirements, meaning they've come in for their services and paid for the device. If that is the case, we will send that to them, at which point they can go down to motor vehicles with that certificate, show motor vehicles that they've complied with everything, MVC will then issue them a new license without the restriction on it. And when they call us and come back, they show us that license that they've been approved to remove by MVC as well. We will then remove the device, and that process takes approximately a half hour to 45 minutes. If they haven't complied with everything, they'll get the same certificate with a different option checked off, and that is that they are non-compliant. If they are non-compliant, we are not allowed to remove the device, and motor vehicles will not remove the restriction from the license. They then need to get back in front of the judge, and this is where they may come back to you, or even somebody who hadn't had an attorney in the first place may be seeking counsel because they do not know how to get in front of the judge. There's not a straightforward process for it, but they need to get back in front of the judge, at which point the judge will make the final determination of whether or not to extend the sentence for 90 days or order the removal of the device. If they order the removal of the device, your client should come back to us with the order from the court. And then there's a third box that we can check off that is ordered by the court after prior non-compliance, at which point we will check that box. They will then take that to motor vehicles, get the restriction removed from their driver's license, return to the service center for their physical removal of the device, at which point they have a valid New Jersey driver's license without a restriction on it. They no longer have the interlock device in their car. Their car is reset back to factory settings, and they can continue with their lives with past all of this. And I know that I did a real broad overview. I know I sent some things out that might have landed, and it has copies of all those different certifications that I had mentioned, so you can kind of get an idea of what the paperwork looks like. MVC is real strict on their paperwork, so we try to keep it straight for them and help the client out as much as possible.
Jason, I have
Jason,
a question
let's
from
do the demo.
Natalie.
Yeah, well,
Oh.
yeah, I got it, Karen, but I got it.
Oh, you
I
got
see it
it.
too. Thank you. Jason, let's do the demonstration, right? Because Assistant Prosecutor Natalie Candela asked, what's to stop somebody from blowing into the machine for a friend or for a relative? So why don't you show all of us how it works, and then let's talk about the intermittent testing that takes place after a person's already been driving.
Sure. So this is the interlock device. Right now, it's as if I started my car. Now, each device requires 1.5 liters of air, and these are NHTSA regulations, and that the device, you have to blow into it in a specific manner. So to let it know that it's a person blowing into the device and you're not using like a long garden hose. So you sort of have to be trained on how to use the device, and let's hope I do well. Each device comes with like a sanitary mouthpiece for each individual. It goes in here and it's ready for me to take the test. This test I'll blow out until the machine registers 1.5 liters of air, at which point I'll have to suck back in, and that's what a garden hose couldn't do, or a balloon. And now the device is analyzing the test, and I passed, thank God. And that's it. And that's it. Now the test will, now my vehicle, it'll allow my vehicle to start. The basic answer to that question of what prevents somebody else, two things. One is that you need to know how to administer the test. I mean, some of them are more difficult than others. They might require you to hum while you're blowing into it. This one is like one of the easiest. Drager's been doing interlocks longer than anybody. But there isn't anything about the machine that will prevent somebody from doing exactly what was described, other than if you are a sober person in the passenger seat and there's a drunk person driving you around, a common sense would prevent that scenario probably from happening. But somebody taking the test for you and then you driving off is a scenario that I've actually seen before. In fact, one time a guy asked a cop, it was an off-duty officer. He says, "Can you blow in this machine for me?" And he just happened to be walking. He's like, but he was a cop, so that was funny. The device requires additional tests while you operate the vehicle. So there's an initial retest that happens within 5 to 15 minutes of that initial test, and me starting the car, and then retest every 20 to 45 minutes while you're operating the vehicle at random intervals. You're not going to know when it's coming. If you pass those tests, your journey continues. like I said, it can't shut an engine off. So if you fail the test, it will not stop the car from moving. It will, however, beep loudly and an alarm will sound inside your car. The only way to stop that, and it's very loud and obnoxious. The only way to turn that off would be to turn the car off. And again, the only way to turn the engine back on would be to administer a clean sample. So that there is a preclusion in that.
So Jason, I will say, first of all, in New York, the machines are required to have cameras on them so
That's right,
that
yeah.
they actually do see who's blowing into the machine.
In New York, they also have probation officers that will look at the video. In New Jersey, motor vehicles has had no interest in having a department to go through hours and hours of that video.
Right. And actually, I hate telling war stories, but I actually had a case where a guy got violated because a friend of his had blown into the car. But in that case, the two of them were at a bar. My client had been drinking, and the owner of the bar said, "Hey, can you move your car to another part of the parking lot?" And my client knew he couldn't drive, so he had his friend who had not had a drink blow into it, move the car, then get out. They violated the client, but when we saw the video, we saw that it wasn't as if a friend blew into it so that my client could drive it.
Sure.
He blew into it so that he would move the car.
And it also is a disorderly person's offense to blow into the device for somebody else, which
Right.
carries with, I think, a mandatory 1 year loss of license.
Right. And the other thing that's interesting about this is that I have clients that say, well, if I put an interlock in my car, does my mom have to blow into it? And the answer is obviously whoever drives the car is going to have to blow into it.
And
So
it's important for that last 30 days that whoever you have drive the vehicle, remember that whatever happens in those last 30 days, which can affect you, is going on your record. There is no way to say, oh, but that was my mom. We have to check the non-compliance box.
Exactly. So that's what I always say. I always say anyone who drives your car is going to have to blow into that device, but be aware that if they get a lockout, it's on you because there is no camera, and the lockout's going to say you had the lockout, and it's going to be hard to get in front of Judge Damiani and say it was my mom who was at happy hour who blew into the machine, not me. So I always say anyone can drive that car, but it's your record. It's like a parking ticket.
Jason, how long is a lockout?
Oh, great question. A lockout, for failing a test, will be 60 minutes. So if I were to not pass that test that I just showed you, a timer would actually show up on the screen, 59 minutes, 59 seconds, and it would count down. During that hour, I would not be allowed to administer a breath sample. So I couldn't even take the test if I wanted to. So there wasn't an opportunity to get the guy over there to come over. I can't even take a test for an hour.
Thank you.
Right. So there's another question. I guess Jason and I can both sort of address this. And the question is, the interlock obviously can't stop somebody from driving a different car that doesn't have an interlock device in it. But of course, the defendant who has now been court ordered to install the interlock now has that restricted license that says interlock. And if they are pulled over in a car without an interlock, it's an indictable offense. Right. So now I always say to clients, do not take this traffic ticket that you only have to deal with for 90 days with an interlock and suddenly have a felony offense against you. It is not worth it. So of course, the license, they can drive any car they want, but they're really taking a big risk by doing that. And another question, Jason, that we had is who gets notice about a lockout when a lockout occurs?
So in New Jersey, it used to be, prior to the law that Warren, the big one that changed in 2019, that nobody got notified at all during the entire period of time. The only part that they added where that becomes so statutorily and as far as the regulations go, unless it's within those last 30 days, there is no consequence for a lockout. Imagine you never operated the vehicle. So the car locked out before you had the opportunity to. However, with many companies, If you get locked out one time or two times, and this is just their procedure, they will charge fees to unlock it. So depending on who you go with, you can get the interlock provider knows, and that's about it, other than in those last 30 days that we're required to report on. There are no statutory consequences. However, there may be financial ones depending on your relationship, your contract with the provider. With us, we don't charge anything for that, but I think all the other ones do at some point, whether it's one or two, or I don't know what their limits are, but before they start charging, but they could. So it could be a financial consequence.
So Jason, you'll have a scenario now, it's the final 30 days. Somebody's coming in now because they're getting ready to have the device removed. You'll do that data download and you'll say, wait, you had 3 lockouts in the past 30 days. You are now on that certificate going to indicate that there's been non-compliance, right?
Yeah, let me just add a caveat to that. The device will lock you out at 0.05. That's what the state has set the threshold at. However, you are in compliance until you've had more than one high BAC in the last 30 days above a 0.08. So you could get 100 lockouts, but if none of them hit that 0.08, or even just one of them hits the 0.08 threshold, you are still in compliance. So you need 2 high BACs above 0.08, and just simply being locked out does not necessarily mean that that's the case. The device is required to not tell the person providing the sample what their BAC is, and that is originally it did, and then you just had people hanging out at bars outside of a car seeing who can blow a higher number.
So then Jay, so the process will be, so let's say there has been 2 BAC lockouts over a 0.08. So now when you send over your paperwork to MVC, you say they've been non-compliant.
We don't send it to MVC, we send it to the client themselves.
Okay, so then let me ask you this, because I have had several cases where the court is notified, and now, as you said, now we go back to court with the client, and the judge has several different penalties that they can impose. So how is it that the court finds out that there have been high BACs?
I'm sorry, in my hurry to go through it, we do notify the court, but between the 500 and some municipalities, I'll never hear whether they got it or not. Like, we'll send a letter, we'll send a fax, you know, the address that's listed. More than likely, the only reason I forget is because we're dealing with the client and hearing from them. We're not hearing back from the court. So we do notify the sentencing court, whatever court number we have for their original sentence, we will, depending on how we communicate with that particular court, every one of them, you know, wants information a different way. We will notify the court as well. We get a lot of calls from courts, though, that will say, I don't know what to do with this. That's why I say it's usually on the client to get back in front of the judge. Don't wait for the court to call you in. Some will, some no, some are, you know, on top of it, but most, I would say, are not.
But what does happen administratively is that, and tell me if this is accurate, you don't get approval from MVC to remove the device, or do you?
No, you cannot with a non-compliant. So once we send the certificate to them, it's on them to take that to motor vehicles. If they took a non-compliant certificate to motor vehicles will not provide them with a license. They need to get that judge to order the removal, and then get the compliance cert that says by order of judge.
Right.
Take that to motor vehicles, and now your restriction will be lifted.
So that is the stick that will cause the client to go back in front of the court, because if they don't, that device will be in indefinitely. They will not have
for sure. Yeah, no,
out.
that's
Right.
Absolutely. There's nothing we can really do about it. I mean, we've had cases where we just had one recently where the guy came back and said, we don't care, take it off. And we're a private business, so it's their car. So we will remove it in that situation. But that person from here on out is required to have an interlock device, and should they get pulled over, you know, the consequence. And at that point, we will also notify the sentencing court that the person has unauthorized, is not complying with the judge's sentence, and did an unauthorized removal of the device.
Right, and even though they took it out, because as you said, I mean, it's their car ultimately, if they say take it out, they're still having that restriction on their license. And now
Okay.
when they're pulled over, you know, that's gonna create a lot of problems. So, Joe, do you want to, I mean, we're coming to the end. I don't know, do you want to open it up to questions at this point? I
wanna
know,
make a few comments. I'd like to make a few comments and ask Jason a question, and we'll see if there are any others. I know we're at the end, but Jason, well, first of all, for the participants, there's going to be a transcript of this on our YouTube channel because Jason gave us a lot of information. So if you have one of these cases and you're like, wow, you know, that was a lot of information, there'll be a transcript of today's proceedings, all of today's proceedings, also a YouTube video, and you can tell your colleagues they might want to take this program who did not participate today. There's also a couple of forms, little handy cheat sheets that Jason has prepared, one for lawyers and one for the lawyer to give to the client that Karen's going to put into the chat client. You can download them from there. And when you get your CLE credits, Karen will also give you those documents as well online with your email to download your completion form for this program. And you'll be able
Joe,
to-
I'm sorry to interrupt. In addition, I need to give everybody the program code to put on their certificate of
Yeah, hold that up.
WDR 11.
W.
And so-
William D. Dominic R. Roger 11. WDR 11.
And I also put that in the chat.
So Warren, I mean, Jason, do you install it or does Mercedes install it or does Infinity install it? For the $4 and change you charge, does a client go to you and you install this in between the engine and the client?
Yes, no, that's exactly what we do. We have the motor vehicles inspects us and certifies us as ignition interlock installation service centers. All the installers have, work for me in our locations. But just so you know, the installation of this is about the same as maybe installing, and maybe even a little less complicated than, say, installing a remote start in your vehicle.
And you also provide the monitoring service, right? I mean, you get data pushed to your company where you can monitor compliance and then issue reports or
And that's correct. So the client is required to return to the service center at 60-day intervals for monitoring checks, and the manufacturer. So the software that we use, the software that we're recalibrating these devices with, is very similar to the software that you see when working with the Alcotest, if anybody's been trained on that, when dealing with the Draeger device and then, others for other devices.
So they have to come back for you to download the data. It doesn't go through the cloud or anything. They have to come back periodically for you to download the data.
Yeah, so it's required that there's that the data is, yes, it's required that the data be downloaded specifically. Also that the device is recalibrated, which requires connection with the device, because we used to use wet bath, like the tube, and you blow through it like you do with the Alcotest. Nowadays we use gas, but you have to be connected to the machine to calibrate the device, hands-on.
Ms. Candella's report earlier, Prosecutor Candela, she talked about someone blowing for you. I was thinking you may be able to game it by leaving the car running, but apparently you can't do that because of the unpredictable intervals where you have to blow it again, right? So you just
Yeah,
can't.
in fact, there's other ways. I mean, you can hotwire a car, you can pop a starter with a clutch, but the device has a gyroscope in it that if it moves without the engine being on, it will register that, and we will know.
Excellent. So to recap, there's going to be a transcript available on the YouTube channel. You're also going to get a cheat sheet eventually, maybe in the chat room now, and you're going to get it if you pay for your registration host program, and you'll get your credits emailed to you by Karen and the PCBA. Is there someone else who might have a question for Jason before we wrap things up? Very interesting, Jason. Anybody else who wants to call out, turn on your mic and ask Jason a question?
Joe, Natalie's wrote in the chat, so the interlock can't stop the defendant from driving a different car that is not his. Or what if he has multiple cars? And also, does anyone get notice of the lockout?
Yeah, we went through those already, Warren and Jason.
Is the court or prosecutor advised? Okay, so you can.
Yeah, we went through those a moment ago, but yeah.
Thank you.
right, and the final question I know Natalie had is, does a defendant have to return to court at the end of the period of suspension? And they do not. Because when they get that order of certification, if the order of certification has, you know, a 1-year suspension, basically followed by, let's say, 2-year interlock, at the end of that 1 year, they go to DMV, and DMV is the one who lifts the suspension as long as they have proof that they've installed an interlock device. And then for the following 2 years, they'll have that interlock license, restricted license. So they do not need to go back to court at the end of the period of suspension. Just one other final thing, Jason, when there are non-compliance, basically when you bring a client back to court, there are several consequences that the court can impose. And what I have found most often is they will extend the period of the interlock. So if somebody had a lockout or in the final 30 days, and now they can't get the interlock out, I will contact the court, or sometimes they get a court notice. We go back and the judge will say, hey, you know, you had this 0.08, you should know better. I'm going to extend it another 90 days that you have to keep the device in.
Yeah, I mean, the majority of the ones we see is in order just to remove it, because a lot of times it'll take that long. It might take 60 days to get into court, and they've already had it, and so we'll get the order. The only other thing I wanted to mention was in the chat, I put my phone number. It's a cell phone number for any attorneys to give me a call anytime if you have any questions. There's an 800 number. That number would be if you want to give a number to your clients, not myself. That's all. And then my email address too is at the bottom also. So feel free to reach out anytime if you think of something.
Karen, can you give us that code one more time for everyone, just in case anyone missed it?
Sure,
Thank you.
no problem. WDR 11.
Thank you, Karen. And it's also in the chat. And that about wraps things up. Anything else, Warren, Hesh, Maite, Chuck, Judge Damiano? We all
No,
good?
Thank you. for
All
this
good. Wonderful
information.
job, everybody.
Thank you.
So in wrapping up, remember a week from today, I believe, next Wednesday, I think it is, right, Karen? We have the DEI program on the 18th.
Correct.
Wednesday, same bat channel, same bat place, all that
So
stuff.
same time?
12:30, I believe. But you'll get a notice from Karen if you're a member of the bar. I believe it's 12:30. I forget.
It
But
is.
anyway, we'll get you that information. That's our last program of the year. Do we have anything else coming up? We had the holiday beefsteak. Anything else we want to promote?
We have
or-
Judge De La Carrera's retirement dinner.
That's in
coming up
January.
January 16th.
Judge De La Carrera will be retiring. We'll get you more of those flyers, and it's going to be a fun time. And thank everybody for coming. Check out our YouTube channel, Passaic County Bar Association at YouTube, and you'll find this one with the transcript if you're interested in the details again about what Jason said or any of us said throughout this program. So have a good week and happy holidays if we don't see you.
Thank you, Joe. Thank you,
Thank
Warren.
everybody.
Thank
Bye-bye.
you, guys.
Thank you to all our speakers. Have a great
Thank-
week.
You too.
Bye,
you.
everybody.
Bye.
Thank you.